Slip and fall accidents are no joke, no matter what the media says. Some of the most serious injury cases I've handled have been slip and fall cases. Often the injuries are complicated and the treatment can go on for years. Medical bills pile up, you're out of work, and the property owner, they say it's your fault. But here's the truth. Many of these accidents are entirely preventable and caused by a dangerous property. I'm Ed Rosenthal, a Connecticut personal injury attorney. I will walk you through a case where a simple fall turned into months of pain and how we held the business accountable. This case happened in Granby, Connecticut. Elizabeth was walking down the stairs to the basement of her friend's apartment when she missed the last step and fell. She broke several bones in the bottom of her foot. She had surgery on her foot the next day and then was in a nursing home recuperating for several months. She was only 25 years old. After months and months, the foot was getting better and she noticed severe pain in her back. She saw a spine specialist and had a herniation in her lumbar spine, her low back. Elizabeth endured years of treatment, including the surgery, injections, and physical therapy. The property owner's insurance company refused to settle the case, even for a very modest sum. I got an engineer to examine the photos of the stairs. He gave an expert opinion that the stairs did not comply with the building code and were dangerous because there was no handrail, there was poor lighting, and the stairs were too steep and narrow. The insurance company got their own expert, and the case was battled in court for several years. Before trial, we settled the case for $150,000 after a mediation with the judge. In Connecticut, property owners are legally responsible for keeping their spaces reasonably safe. That includes fixing hazards like wet floors, icy sidewalks, or uneven steps. And if they can't fix it right away, they're supposed to warn you. We call this premises liability, and it's all about proving that the owner either knew or should have known about the danger and didn't do anything about it. One thing people don't realize is that timing matters a lot. For example, with snow and ice, property owners have a reasonable amount of time after a storm to clear the snow or ice. If someone slips first thing in the morning while it's still snowing, it might not be a case. But if that icy patch sat there for a week without salt or warning signs, that's negligence. That's where we come in, gathering the photos, witness statements, and even surveillance footage when we can. And just like with other injury claims in Connecticut, you typically have 2 years to file. But don't wait, these cases are strongest when we act fast. If you slipped and fell on someone else's property here in Connecticut, don't brush it off. It could be negligence, and you could be entitled to real compensation. Call me today for a free consultation, and let's talk about what your case might be worth.